before the court is Kimberly Nowack versus Zachariah Render. Appellant is Mr. Render in this case. Mr. Markley, you ready?
I am, Your Honor.
All right, you are the only side that submitted a brief, so we will hear from you, and you'll have nothing to rebut. So I'll start the clock when you begin. Keep in mind, we are videotaping, so keep your voice up, stay behind the podium, and don't use the names of any children, although I don't think that's an issue in this case.
Right. Thank you. May it please the court, I do represent Zachariah Render. Mr. Render was unfortunately hit with a civil protective order for what I believe to be actions that are inconsistent with the statutory requirements for the granting of such an order. If I can go back to the statutes, it is indicated in 2903.211A1 that a pattern of conduct must occur that knowingly causes another person to believe that the offender will cause physical harm. Pattern of conduct is two or more incidents closely related in time. What we have here is a situation where two high school seniors were dating. They had a very short-term relationship that lasted from sometime before Christmas till February 11th, when he received what I called a Dear John text from her. It says, it's time to go our separate ways. We both have different things to do. They were going on to college, all of those sort of things. So he filed a response to that, and he was kind of hurt by that. As high school seniors often are, and children are a little more dramatic sometimes than other people. And he said eloquently that my insanity has increased 10,000-fold, and the judge seemed to focus on that. But he also said, thank you for doing this. My life will now be better without you. There was no threat apparent or as part of that post. That was the last communication he had with her until she filed this in the end of May of 2018. So why did she file it? Well, she thought he was in a car that came up to her house with another individual by the name of Steve Waltos. As the evidence clearly established, Zachariah Render was not in that car.
That's not exactly what the court said. I mean, the court said there wasn't enough evidence to show that he was in the car.
Well,
Which,
yeah,
for purposes of your argument, is, I guess, the same.
yes, and if you look at the exhibit that he provided, he has a Google summary of where he was that day, because it had occurred just recently, and none of those places that he was at included her home. She even indicated that she recognized the voice of Steve Waltos and did not hear the voice of Zachariah Render, could not see into the car because it was dark at the time, but assumed that he was there. In fact, the only contact that she had with anybody from February 11th forward was with Steve Waltos, and her testimony was that he, Steve Waltos, said, "You're going to pay for this." He didn't say that. He didn't say anything. So the interesting testimony was, well, Ms. Nowack said, I knew we needed 2 incidences. This was one. The May incident was one. But why would she know we needed 2 incidences, and why would she then search for another one? The fact is that Zachariah Render never threatened her in any way or manner whatsoever. They now go back to some conversation that occurred in January, which, by the way, was precursed by her comment that I was asking him what would happen if I made him angry. He didn't threaten her. They were having a conversation back and forth. He denies saying what she says he said. He said he wouldn't say those things. There's no text. There's no confrontation. There's nothing. There's 2 high school kids driving around in a car having a theoretical discussion about what would happen by her own testimony if she made him angry. If he did say, I wouldn't hesitate to hit a woman, that would have been a poor choice of words, but there was no indication that there was any fear, or that he was knowingly trying to generate fear. He was not saying to her, stop this conduct or I will hurt you. He was responding to her, by her own testimony, theoretical comment. They didn't break up for 3 weeks after that. Well, she's not sure. It could have happened in January, it could have happened in February, it could have happened perhaps at the bonfire in December. Testimony was absolutely unclear. And I understand that we're here in the appeals court and it's manifest weight of the evidence, but still, this is a trier of fact, that is the judge and a magistrate. And it's something that impacts this young man's life, and they should be careful with these things. That's why we're here. Nowhere did anyone say he threatened her in any manner whatsoever. Nowhere did he back her into a corner. Nowhere did he appear at her house. Nowhere did he follow her around. All of those things that a domestic violence statute, a menacing by stalking statute, is designed to prevent. It's the prevention of what's to happen in the future. This just isn't enough.
What's in the record about this, the court made a finding about pulling a machete out of his waistband he was carrying with him? Can you elaborate on that?
Yeah, first of all, I found that basically unbelievable that a kid would walk around and go into a Jimmy John's restaurant, sit down with someone and pull a machete out of his waistband and place it on a table in public view of everybody. He, of course, denied that it happened. The testimony about knives was not even in the petition for the civil protective order. If it was a significant factor, it would have been included, I would imagine, in a petition.
Well, I guess the question is what's in the record about?
So, what's in the record is the brother saying, I saw him pull it out, place it on the table. There was no conversation about it. There was no threats made with it. It was her brother that testified that, and there was an unclear response as to whether he even had a conversation with his sister about it. The sister, who was the petitioner's daughter, was not present, if that did in fact occur. And again, Mr. Renner denies that it does. I find it difficult to believe that if this was within everyone's knowledge, that it wouldn't have been included in a petition. What was part of her testimony was, yeah, he said he had a knife and he said he had a gun, but I never saw either one of them. And by implication, also, he never threatened her with any of those things. There's just there's no threat, there's no knowing action creating a fear in somebody. And if all of these things, which occurred in the period of time from December to early February of 2018, did in fact occur, where was the request for the civil protective order in February? Where was that? Her testimony clearly said, when this happened in May, I was afraid. And the judge found in that case that he was not proven to be participating in that. And in fact, I think if you read the evidence and look at the exhibits, you'll see that he simply was not there. And again, the only comments between February and May that the child had problems with were those made by Steve Walters, not by Zachariah Render. And she told him, you better stop it. She didn't send Zachariah a text saying, you better stop it. She didn't have to. He wasn't doing anything. This was an ill-brought civil protective order. 74 pages, that's it for the transcript. There wasn't much there. Well, there was the time that she drove by his place of employment soon after her breakup, and he flipped her off and went back to work, as she said. If a civil protective order was issued every time somebody flipped somebody off, you had to be very busy. He was upset and hurt. He wasn't threatened. Read the post. Read the end of it. This is not the night of my death, but the night of my birth. A new beginning with a new mindset that I could have never experienced before. I thank you. It's not a threat. And nobody can understand that to be a threat. It's just, there's all these different inconsistencies. The petition only said that they had that conversation in the car in January, that he was kicked out of the Career Center, which nobody ever brought anything to show that he was, and he said, no, I graduated in May. I graduated just around that time. And then on May 27th, Zachariah and Steve Waltos came to the house and called Hannah out. But she didn't hear his voice in testimony. The magistrate then said that the January threats were an assault and the post was the second event. He did not find anything else. He never mentioned a knife. He never mentioned a gun. He mentioned this post, which I beg you to read and find that that is not a threat. Judge Kimberly then went beyond that and broke the conversation down into two parts and said this conversation in the car therefore was two separate incidences. I don't think you can do that. There's also, again, no expression of knowingly causing someone to believe that they are going to be in fear of physical harm. She also said that he told others that he had a weapon. He never said, I had a weapon to anybody. They mentioned that he had a knife. But again, not in the petition, just in the testimony. Your Honors, I know that, and I don't appear before you often, and I understand that the issue is a weight of the evidence argument, and it is. Because, as you've overturned other cases, it just isn't here in this case. And this young man doesn't deserve the permanent blot of a menacing by stalking order on his record for these things, for a 3-month relationship with a young lady in high school. Again, never contacted her after she broke up with him. That's not a threatening person.
What about the comments about if you think I was insane before, wait, you haven't seen anything yet?
It says, you thought my insanity was bad before, oh, you just wait. It's amplified itself tenfold. Yes. Life now goes by at 10,000 miles an hour, and I see every possible outcome. I've had a lot of high school kids in my time. I have 8 children of my own. Kids talk. Where's the threat? Where's the comment?
Well, what about that coupled with the fact that the testimony, now, keep in mind, I'm not saying that it was believable, but the trial court obviously believed it. That she said that he indicated to her that she, I'm going to use the word ticked him off instead of the other word. She ticked him off, that he wouldn't be hesitant at all to feed her case in.
And the earlier testimony to that was she was asking him theoretical questions that led to that comment. The comment didn't come out of anywhere. She was saying, well, what would happen if you were to become angry?
Well, at that point, she may have been thinking, I'm not going to break up with him, I want to see how he's going to react. And that may be a reason why she texted him instead of telling him in person, because he already said he would beat her face in if she ticked him off.
And yet he didn't contact her after she did that, other than to write a to whom it may concern post, because somebody breaks up with you by text instead of in person. But my personal experiences don't count, but I have to tell you, this is the way kids talk. This is the way this is the way they communicate one with the other. They communicate through Instagram, they communicate by text. There's no threat associated with it. Why was she not in court after that? What happened over the next 3 or 4 months? Nothing. So you have to look at it in the context of what she actually did. And the only complaint she had in that period of time was against that other person named Steve Waltos. He wasn't even there. And to say that, therefore I was afraid because of this conversation and because of this post, they were quite capable of filing a CPO. They did it on their own.
Your time's up.
I was just, oh.
You want to make a summary statement?
Yes, Your Honor, I really truly believe that this is a case that was a struggle to begin with, that the evidence should include an examination of the petition and what the petitioners thought was important enough to put into such a petition, that the evidence did not uphold that there are no indications of threat, that we have a knowing standard when we review whether he believes he would cause her to be in fear of physical harm, and that the evidence simply did not support that, nor did it support that there were 2 or more incidents of such. I would ask that you reverse the protective order that was issued. Thank you.
Thank you. All right, we'll take the matter under advisement, issue a written decision in due course, which will be mailed to both sides as well as posted on our website and on the website of the Supreme Court. Thank you.
Thank you.